Hello, this is social media attorney Mark Fiedleholtz, and welcome to my podcast on how the eroding qualified immunity defense impacts public employees using social media. I'm going to approach this podcast with a question and answer format to optimize the flow of information. Let's get started. First question: what is qualified immunity? Answer: qualified immunity was designed to regulate and narrow the number of Section 1983 civil rights lawsuits against public officials/employees performing discretionary functions. In short, it's a legal principle, an affirmative defense that acts as a high bar for claimants to hurdle in Section 1983 cases. To overcome qualified immunity, a plaintiff's attorney would have to prove that the offense was unconstitutional and that it was clearly established law that that particular set of facts that is in the instant case being presented was unconstitutional. So, in other words, is that the precedent that you're using has the same exact facts where the court has ruled that it was unconstitutional. Otherwise, you're not going to win, and the individual, the claimant, will be able to postulate an affirmative defense of qualified immunity. All right. So let's go to the second question. If qualified immunity is such a high bar, what are you worried about? Well, the concern stems from recent United States Supreme Court decisions, especially the one in Taylor versus Rojas. In this case, an inmate was forced to spend 6 days in appalling conditions in a jail cell that was completely covered with feces. Since there was not an earlier case stating that condemning a prisoner to 6 days in an unsanitary hell like this one with feces all over the jail cell is unconstitutional, the Fifth Circuit Court of Appeals predictably granted qualified immunity to the prison guards, which basically means is that you couldn't sue them. Now, breaking with tradition regarding these qualified immunity decisions, the United States Supreme Court reversed in the Taylor case. So, despite the lack of a precedent matching the exact circumstances at issue, it was significant because the United States Supreme Court held that any reasonable officer should have realized that Taylor's conditions of confinement offended the Constitution. It was obvious, the court said. So, that was definitely a switch from traditional qualified immunity decisions. Also, in another case, Tanzan versus Tunavar, that this case is a little different because it didn't necessarily involve qualified immunity as an issue, but the reason I brought it out to you is the government's briefing in this case heavily relied on the same arguments used in qualified immunity cases. So here, the Supreme Court, United States Supreme Court, granted a resounding victory to Mohammed Tanvar, who had previously been told he could not sue FBI agents who retaliated against him for exercising his religion. That for policy reasons, courts should not allow damages against government workers. All right. And that's, that was the conventional thinking. But here, the Supreme Court shifted and disagreed, stating that Congress is free to engage in policy making, but there are no constitutional reasons why the United States Supreme Court has to in a case like this. Then there is the last case I want to share with you, which is McCoy versus Alamo. The United States Supreme Court granted a petition for certiorari. Now, the judgment of the Fifth Circuit Court of Appeals was vacated and remanded back to the court for further consideration in light of that first case I mentioned with Taylor versus Rojas. So this is very significant. In the McCoy case, a Texas prisoner named Prince McCoy was pepper sprayed for no reason. The officer was agitated with another prisoner who had twice thrown water at him. But because this other prisoner was out of reach, the guard took it out of McCoy, an innocent, and he was also had asthma. So the video, though, that was taken after the incident shows McCoy pacing in his cell, unable to breathe, and then McCoy sued. But until the Supreme Court intervened, he was denied justice. Now, courts at all levels now have held that because there was not an earlier court stating that macing an innocent inmate is unlawful, the officer cannot be held unaccountable. But here, the United States Supreme Court said, no, that's not the case. So these cases represent the early stages of a seismic shift away from courts granting an automatic qualified immunity defense in cases where the claimant is unable to cite a U.S. Supreme Court decision or relevant federal appeals court decision that clearly establishes the precise conduct in question as unconstitutional. More specifically, courts are viewing 1983 violation claims through a totally different legal lens. Instead of placing premium importance on the policy of protecting public officials from being distracted by lawsuits, the United States Supreme Court is now injecting the reasonability standard in their 1983 case analysis. This new school of thought was displayed, as I mentioned before, in Taylor versus Rojas. All right. So I guess the final question would be, what impact does the new U.S. Supreme Court view on qualified immunity have on social media in the public sector? Well, let's be clear. The affirmative defense of qualified immunity never had a strong foothold as an affirmative defense in social media related cases anyway, all right? It's not like the use of force where there's a lot of discretion. Here in social media related cases, the legal examination of the facts is applied to a long and deep history of clearly established U.S. Supreme Court and federal law that you cannot go on mass media platforms and defame, harass, threaten, and engage in other reputational harm that isn't covered by First Amendment speech protection. Additionally, many of the offensive comments on social media are intentionally directed at people who are, in fact, members of a federally protected class. So here's the problem. If you add the U.S. Supreme Court's new shift towards applying a reasonability standard in determining validity of qualified immunity affirmative defenses, and social media now never really took to qualified immunity anyway because of the circumstances of the case, you have a very risky area here for public officials who think they can vent opinions and humor on social media with impunity. This especially applies to off-duty posts and tweets sent from a private social media account or personal device. Many public officials are unaware that in determining liability, courts focus on whether the work-related content was constitutionally protected, not whether the message was sent off-duty or on duty or on a private social media account. Combine this misperception with a loss of qualified immunity protection, and public officials are starting, they're really looking at something now that's almost like the proverbial double-barreled legal gun of being sued in their official and individual capacity under Section 1983. It's not a good situation. So a lot of people will say, well, what's your cost-effective solution here? And I have one. And what you need to do is immediately register all your employees for my low-cost social media liability online course. If you don't make the comments in the first place, you don't have to worry about using shaky affirmative defenses like qualified immunity. You will stay far away from the courtroom. My online and live courses dispel the myths surrounding social media, opinions, humor, and privacy issues, which, by the way, is really the root of all the problems anyway. I also use my over 30 years of digital media law experience to teach you a new red flag warning system that's not taught anywhere else, and that basically gives employees the ability to identify and eliminate high liability speech before they hit the send button. So here's the bottom line again. You can't wait for a social media mistake to ignite costly lawsuits that destroy the public trust and ruin careers. Courts consider every employee a broadcaster and publisher that can reach millions and create a permanent digital footprint. The days of having a sense of security because you gave your employees verbal warnings and handing out a boilerplate social media policy are over. Well, that's the end of the podcast. So what I'd like you to do now is email me or call me to register all your employees. Hopefully I made a compelling argument for you. All right. The information should be on the flyer that you received, and you will find all the contact information, like I said, on that flyer. And that's it. So I really felt compelled to share this information with you. Thank you for taking the time with me. This is the end of the podcast.